Mr. West argued, at least pled some, quote, affirmative defenses. It appears that the trial court concluded that some of them weren't properly pled or supported by evidence. Is that a correct recollection?
Correct, Your Honor. And he did raise waiver and modification of the agreement. And because there's no transcript of the proceedings, it's difficult for you to determine whether the court aired or not. However,
well, looking at the emails that were attached of his communication with counsel, it doesn't appear that there was A, an offer, or B, an acceptance that would modify the existing agreement, or did I not read them correctly?
you read them correctly, Your Honor, and that's the big issue.
It was a wish of good luck. I think that's what one of them said, good luck.
Good luck, exactly. Or I wish you luck in your future endeavors or something like that.
I think he said he was going to close on a deal and have the money, and he said good luck, something like that. Yes.
Correct, Your Honor. And the issue that resolves this, or the law that resolves this, is if you look at the integration, no waiver, no modification clause in the engagement agreement, which is 14, it specifically states that the terms of this engagement agreement shall not be waived or modifiable without the written, manually signed consent of the firm, and no acquiescence shall be binding for the firm. And the allegation in the brief is that although there is a no waiver, no modification clause, there is case law that allows an oral modification that can trump no waiver, no modification clause. And that is correct, but there are some requirements for an oral modification to modify a written contract with a no modification clause. And the Supreme Court said it in Cahill, which is a little complicated case, but the gist of it is that you have to have consideration. The Okeechobee court actually explained that very well, and I'm just going to read a quote from Okeechobee explaining Cahill, and it says, Cahill's requirements are not disjunctive, and a party seeking to enforce an oral modification in the face of a no oral modification clause must show that the parties accepted and acted upon the alleged modification. And then it goes on to say, and that a refusal to enforce the modification would work as a fraud, because the party seeking to enforce the modification provided and the resisting party accepted additional consideration for the modification. And in this case, clearly there was no additional consideration to support the oral modification. Therefore, the no modification clause in the engagement agreement is the one that would be applied and should be applied by this court, which and the engagement agreement clearly states that invoices are due upon receipt. So that is my presentation. If you have any questions, I'll be happy to answer them.
I don't see anyone. You apparently were very persuasive. At least you prompted no questions. So we thank you. Have a very good holiday and stay well.
Thank you. You too. Happy Thanksgiving.
Thank you.